All right, next chapter is Chapter 5, Legal Liability. Under certain circumstances, a CPA firm may be considered liable for losses by another party. And so our job here is to look at that. As the book notes, there's quite a bit of litigation. We live in a litigious society, and when there's a loss of any kind, those persons losing, usually in the case of either the company losing money because of some fraud that wasn't uncovered, or investors who lose the money they invested in a company that goes bust. You know, they look to anybody and everybody when that happens, and so under the what I call the deep pockets theory, they sue everybody involved. And so from that extent, CPA firms are kind of a target. So it's not uncommon to have to deal with lawsuits in a CPA firm. Bottom line is, if you work in a CPA firm or you have your own CPA firm, first thing you do is get malpractice insurance. It's your number one safety net. Not that you want to use it, because if you use your malpractice insurance to defend against claims, and you have enough claims against you, pretty soon the insurance company is going to either drop you or raise your rates up so high that you'll have to drop them. But in the rare case where you may be sued, you really need to have malpractice insurance. So, understand the litigious environment in which CPAs practice. As I just said, certainly audit professionals have a contractual liability with clients. And because of that, certainly if the audit's not done as claimed, clients have the option of suing the accounting firm for breach of contract. And usually the loss there is whatever was promised versus whatever was lost. You know, usually the loss is not that great. What usually happens is, and you're only going to find breach of contract, I mean, kind of again, when parties sue, they'll throw in the kitchen sink into their lawsuit and allege breach of contract, negligence, and all this other stuff, fraud. So, you know, just because they allege it doesn't mean it happens. But that's usually not where the big bucks lie. It's usually in the negligence and other things such as fraud allegations. If those can be proven true, that's where the money is, and that's what these people are looking for. So auditors can be liable for breach of contract, possibly. They can certainly be liable for negligence if they don't use a certain standard of care in their services. And note here that the number of lawsuits and the size of the awards remain high. Understand the dynamics here. The suer, the party suing the CPA firm, wants to get this in front of a jury. Almost often, like 99.9% of the time, they want to get this in front of a jury, or at least, you know, have the CPA firm and their lawyers consider that what may happen if it gets in front of a jury trial, because juries are not CPAs usually in these cases. And so they're not going to really understand what the CPA's duty is. So, and so, you know, they may, many times, these juries side with the plaintiffs, the party who suffered a loss, allegedly, simply because they don't understand how to apply the facts to the law. So, bottom line is, there's a lot of lawsuits out there against CPA firms, and the awards keep climbing. Some major contributors to the number of lawsuits filed, as well as the number of larger lawsuits or judgments, are growing awareness by financial statement users. Growing awareness of what, you might ask? I would almost say growing awareness that if there's a loss, if they suffer a loss, they can file a suit against the CPA firms. I'm not sure what the publishers here or the authors here are trying to say is the growing awareness, but I would say that it's growing awareness that they can sue if they suffer a loss. Increased consciousness of the SEC, which we'll talk about here later. Complexity in business drives complexity in auditing and accounting functions. Again, it gets back to the auditor knowing the business of the audit client, regardless of how complex it may seem. It's not rocket science. And last but not least, as I mentioned, we are in a litigious society here in the United States. Global recession and tough economic times. A lot of companies have gone under, and you know, the users of these financial statements, once they suffer a loss, look to anybody and everybody to point fingers for the loss. And again, CPA firms are marked in that instance because, you know, the general public thinks that CPA firms are a guarantor of, number one, the numbers, and number two, the continuing existence of viability of the audit client, and that's just simply not the case. When people who lose money in investments see these large judgments against CPA firms, it certainly incentivizes their willingness to go out and file a suit as well. We'll talk about how to combat some of this litigation. You know, willingness of CPA firms to settle out of court. Certainly, if the CPA firm did something wrong, didn't meet the standard of care, they probably should settle out of court. But many of these firms are settling out of court just to keep it hush hush, and that's probably not the right way to take care of this stuff. If they have a good defense, they should probably vigorously defend the case. That would stop some of these lawsuits. Judges and jurors' difficulty in understanding technical accounting and auditing matters. Jurors are a jury of peers, supposedly, but certainly not peers of the CPA firms, usually peers of the plaintiff. So they certainly don't understand the highly technical accounting and auditing matters, and so this leads to a lot of not necessarily the lawsuits, but the escalating judgments that come out of these lawsuits. And so the second objective for us is to explain why the failure of financial statement users to differentiate among business failure, and audit risk that has resulted in lawsuits. We have an expectation gap here, okay? And so let's define what these are. Business failure is when a business is unable to meet its obligations or investor expectations due to economic or business conditions. Audit failure is the auditor issues an incorrect opinion because they failed to follow generally accepted auditing standards. And then audit risk, is the risk that the auditor fails to find a material misstatement and issues an unqualified opinion. Well, there's always going to be audit risk in any audit. Because, again, the auditor is not a guarantor of results. The audit does not cover every transaction that the company makes. They don't try to recreate the accounting records of the audit client. So there's no way that the auditor guarantees the results. But yet, clients don't understand that. The client company doesn't understand that. The investors don't understand that. And certainly jurors and judges don't understand that. All right, so now we're going to talk about the primary legal concepts and terms concerning accountants' liability as a basis for studying legal liability of auditors. All right, so the first thing we need to talk about, usually when someone suffers a loss as a result of relying on financial statements that have been audited, they're going to sue again for everything under the book. And depending on whether or not it's the audit client or a third party, they're going to use certain legal terms in relation to this lawsuit. Certainly if it's the audit client, they could argue that the auditor breached the contract by not doing whatever they were supposed to do. But there's not really much money in that, so it's usually something they throw in, but usually not where the money lies. Where the money lies is in the negligence claims. And so when someone, either the audit client or possibly a third party, files suit against a CPA firm, one of the major things they're going to allege is that the auditor was negligent in their duties. And so essentially what they're saying is, and it's under this prudent person concept, is that a prudent CPA would not have done what this CPA firm did in this particular situation. So they call it a prudent person concept, but when you're talking about the negligence of a CPA firm, you're talking about prudent CPA concept, really. So that is a big part of what we talk about when we're talking about negligent, is would a prudent CPA done the same thing as this CPA firm under the same circumstances. Note that when you're in a CPA firm, you may have some CPAs who are negligent where others aren't. And so the question is, does the non-negligent CPA, are they responsible for the other, for the loss caused by the negligent CPA? And it kind of depends on the type of business setup that the CPA firm has. Certainly if you're a sole proprietor CPA, you're totally responsible, and your business assets as well as your personal assets are subject to the claim of the suing party. Certainly if you're in a general partnership, that's true too. Both partners are liable, even personally liable. Some of these other business organizations that CPA firms can set up as, not so much. And so LLC, LLP, corporation, general corporation, you're only responsible, if you're the non-negligent CPA, you're only responsible for personally if you're personally involved in the negligence. If you are a CPA who is non-negligent and not participating in the negligence, then you're only liable up to the amount of your business investment in the CPA firm. Your personal assets are not at risk. Note that under common law, CPA does not have privileged communications with their clients. And so, at least under common law, there is no CPA client privilege like there is attorney-client privilege. Now, certain states have enacted statutes which allow for CPA client communications to be considered privileged, but only in those states can you do so. All right, so here are some terms, legal terms that you might deal with in a lawsuit. Ordinary negligence, it gets back to that, what an ordinary prudent CPA would have done in the same situation. If not, if they would have done something different than what the CPA firm, the defendant, had done in this audit, then they're probably guilty, not guilty, but liable for negligence. Gross negligence, that's where you're just kind of having a reckless disregard of the facts and not even slight care. A lot of states do not distinguish between ordinary and gross negligence. They just simply bunch it all together. And if using the prudent CPA standard, whether you're ordinarily negligent or gross negligence, doesn't really matter. They don't look at the extent of the negligence. It's just either one, you could be liable. Constructive fraud. What they have, they call it existence of extreme or unusual negligence, even though there is no intent to deceive or do harm. Not sure if I see the difference between that and gross negligence. I think what they've done is just basically torqued up the gross negligence to constructive fraud, because constructive fraud, as it notes, is also termed recklessness. And then last but not least, fraud. Here, for a CPA to be liable for fraud, and this could be literally both a civil matter as well as a criminal matter, but at least in the civil matter, to be liable for fraud, the CPA has to know that whatever the statement they're making is false, and that, well, they have to know at the time they make the statement it's false, and they also intend to have whoever the party relying on this statement, they have to intend for that party to rely on that statement, false statement. Kind of a hard, you'd have to be doing something pretty extreme as a CPA to be liable for fraud. You would have to almost be complicit in whatever's happening with the audit client. Again, like I mentioned, you could be liable for breach of contract to the audit client. Now, again, not everything a CPA firm does is an audit. What if you're doing a review or a compilation? So, I mean, you could have breach of contract in those types of cases as well. Usually the problem with breach of contract is based upon how clear the wording of the contract is. First and foremost, when you accept an engagement, whether it's an audit, review, or compilation, get it in writing. Okay, so that's the first thing. Get it in writing. Second of all, make sure that the writing, the contract, explains with great clarity the scope of the engagement. What it is, what it isn't. Okay? Because if you can do that, what better proof, what better defense to a breach of contract suit to say, jury, here's a copy of the contract. It specifically says in here that we are not doing an audit. And, you know, if this client's a review or a compilation and they think they're getting an audit, well, it's right there in writing that they're not getting an audit. So a lot of these problems can be clarified in a well-written contract, okay, that tells what the auditor's responsibility is, what the client's responsibility is, what responsibilities the auditor doesn't have. Now, the question is, what if a party is not a party to the contract? In other words, let's say we have an audit client, a company, and they have creditors, banks, trade creditors, whatever, who are relying on the financial audit before they extend credit. Question is, can they sue the audit company, the CPA firm, if the company can't pay its bills? And so there's a long line of cases involving this. before I get to that, talk about CPA liability to clients. Again, if it's under the breach of contract, you know, you can show that there was no breach, that there was a lack of duty to perform. That's a defense. Certainly, if they file also claiming negligence, the plaintiff does, you could certainly deny that your performance was negligent, and then you would have to show, well, number one, when a plaintiff files suit, the burden of duty, the burden of proving negligence, burden of proving breach of contract is on the plaintiff, not the CPA firm defendant. So, but as a defense, you could certainly argue under breach of contract that, you know, you didn't have a duty to do this. It's not in the contract that we're supposed to audit. We're just only supposed to review the financials. Under negligence, you could also claim that you are not negligent, although it's up to the plaintiff to prove that you were negligent. It's their burden of proof. When it comes to being sued by an audit client, and this includes audit or review or compilation, you could argue contributory negligence. This is where you're alleging that the audit client has done something to contribute to the CPA firm's negligence. In other words, they limited the scope of, for example, the audit client limited the scope of the audit. They wouldn't let you do an inventory of the company's inventory. They wouldn't let you do a physical count of the inventory. They wouldn't let you verify accounts receivable, things like that. Then the last thing you could do is argue that there's an absence of causal connection. What the plaintiff must show is that there's a connection between the negligence of the CPA firm and that caused their loss. Well, if they have to prove that, but you could also turn that around and use as a defense that there's no causal connection between what the auditor did or their negligence and the loss. And so anyway, there's those defenses. Anyway, back to when does a third party get to claim negligence? I mean, certainly third parties don't have what's called privity of contract. They're not a party to the contract. But in certain circumstances, if that party is what we call a third party beneficiary, they could sue under breach of contract. What is a third party beneficiary? And so what they've done, they've kind of taken three different approaches to this. The most popular approach is called the ultramarines doctrine, and so in that case, the court held that although the accountants were negligent, and so, you know, this is not just breach of contract, this deals with negligence as well. Says that the CPAs were not liable to the creditors because the creditors were not a primary beneficiary In this context, the primary beneficiary is one about whom the auditor is informed ahead of time before conducting the audit. And so essentially what they're saying there under the Ultra-Meyer's doctrine is that in order for a third party, in this case the bank, to be able to sue for negligence, the bank would have to prove that the CPA firm knew that they were auditing these, auditing the audit client's financials for the benefit of the bank. Here the bank didn't know, I mean the auditors didn't know that. Now other courts have tried to expand this Ultra-Meyer's doctrine, and so there's some other approaches, and different jurisdictions use these different approaches. So you kind of have to know what approach a particular jurisdiction would use to determine you know, how far this third-party beneficiary could go. At the other end of the spectrum, you know, the Ultra-Meyer's doctrine says that the CPA firm has to know of the third-party beneficiary and that this audit is being used for their benefit. Kind of at the very end of the spectrum is this foreseeable user doctrine, meaning that the CPA firm is liable to any user that they could reasonably foresee using this information. Well, you know, that's practically unlimited. So I would think, my personal opinion is probably very few, but some pretty liberal jurisdictions probably handle it that way. And then there's, you know, maybe a couple of different approaches that were somewhere in between the foreseeable user theory and the Ultra-Meyer's doctrine. One of them is the Credit Alliance case, which held that the auditor must know and intend that the work product be used by the third party for a specific purpose, and knowledge and intent must be of the CPA must be evidenced by their conduct. So, and then there's the restatement of torts approach, and this is followed by most states. And so third-party beneficiaries under the restatement of torts is foreseen users who must be members of a reasonably limited and identifiable group who have relied on the CPA's work, such as creditors, even though those persons were not specifically known. Okay, so again, the Ultra-Meyer's and the Credit Alliance, you've got to have a known beneficiary, where restatement of torts is a little broader. If there's an identifiable group, such as creditors, identifiable group of users such as creditors, then they could be considered a third-party beneficiary. That's not quite as broad as the foreseeable user. That could be practically anybody. That's very few states use that. Again, when you're dealing with these supposed third-party beneficiaries, defenses that the CPA firm can use are lack of duty to perform the service, non-negligent performance, and absence of causal connection. So here's, like I talked about, the four major sources of legal liability. Liability to clients. Client sues the auditor for not discovering a material fraud. Liability to third parties. Bank sues the auditor for not discovering the borrower's financial statements are materially misstated. And then two others we'll talk about here: civil liability under federal securities laws and criminal liability. And so here's, again, those defenses you can use against clients. There's the ultramarys doctrine, and then foreseen users doctrine, and then, you know, these three things that we talked about. And then you have your defenses, three defenses you can use against third-party suits. All right, next we want to talk about the accountant's civil liability under federal securities laws and related defenses. Not that there's many cases on this anymore, but Securities Act of 1933 imposes an unusual burden on the auditor, essentially, well, several burdens actually. And Section 11 of the 1933 Act defines the rights of third parties, the persons using these financial statements in what they call registration statements. These registration statements, when a company wants to sell its securities on, like, the New York Securities Exchange, meaning publicly traded securities boards, they must file a registration statement, and part of the registration statement that they file includes audited financial statements. And so, again, this Securities Act puts some burdens on the auditor. And so let's look at what those burdens are. First of all, get back to this. Love how they don't talk about it. They just throw something up there on the screen. Couple of things that are burdensome to the auditor. In these financial statements that are audited, that are part of the registration statement, the auditor must make sure that the statements are fairly stated all the way through the date, well, the date of the registration statement. And so the problem there is that sometimes the registration statement will be months after the date date of the audit. In other words, let's say the audit is through 12/31/14, but the registration statement's not filed until November of 2015. Well, essentially, the auditor has a continuing obligation to make sure that those financial statements are fairly stated all the way through the date of the registration statement. So they essentially have to keep auditing all the way through to November of 15. The other thing that's kind of unusual here is when a user of the financial statements, let's say a potential investor does invest in this company, and it turns out that they lose money for whatever reason, well, if they want to sue the auditor under the Securities Act of 1933, usually they're going to allege negligence. What's unusual about the Securities Act of 1933 is that normally the burden of proof would be on the plaintiff to prove negligence. But what the Securities Act of 1933 has done is put the burden of proof on the CPA firm to prove they're not negligent. So the suing party doesn't have to prove the CPA was negligent. The CPA firm has to prove they weren't negligent. So luckily there's not too many lawsuits that come under the Securities Act of 1933, but it could be kind of a dangerous thing for a CPA firm. Securities Exchange Act of 1934 deals mainly with financial statement, financial statement burden required of publicly held companies after the initial offering. And so here they have to, publicly held companies have to file yearly audited financial statements as well as reviewed quarterly statements. And so auditor liability under the Securities Act of 1934 usually deals with audited financial statements issued to the public in annual reports. Again, they don't have that same burden as with the Securities Act of 1933, but it's still there. Moving on, the Securities Exchange Act, well, Securities Exchange Act of 1934 has something called Rule 10b-5. And most of it deals, I mean, there's a lot that it deals with. It's called the anti-fraud provisions. And, you know, some of this deals with insider trading and things like that. But the bottom line is the courts have ruled in this Hochfelder case that for a CPA to be liable under Section 10 and Rule 10b-5 of the Securities Exchange Act, they must have had the proper state of mind to be liable. And that proper state of mind is that they must have what's called scienter, which is defined as, in this case, the auditors must have the knowledge and intent to deceive in order to be liable for a violation of Rule 10b-5. So the proper state of mind is that they have a deceptive frame of mind at the time, you know, they made whatever statements they made. Usually it's a published statement. So, I mean, that's a pretty high burden to say that an auditor had knowledge and intent to deceive. That's a hard burden to meet. And then on top of all the other things that can happen to you when you're auditing a public firm, you can be subject to SEC and PCAOB sanctions and possibly suspension. And note that the SEC has temporarily suspended and sometimes permanently suspended a number of individual CPAs from auditing SEC clients. FCPA, it's really kind of hard to meet that. not really just too concerned about that. Sarbanes-Oxley Act. Remember that this, under Sarbanes-Oxley, the CEO and the CFO are required to certify that the financial statements filed with the SEC are fairly stated. Management must report on the effectiveness of internal controls over financial reporting. And of course, the auditors, their job under the Sarbanes-Oxley Act is to provide an opinion on both the internal controls, the adequacy of internal controls, and whether or not the financial reports are fairly stated in accordance with GAAP. Criminal liability for accountants, very rare that liability accountants are going to be held criminally liable, but it's certainly worth something talking about. And essentially what you have to do is almost become part of whatever is going on. And so says here all these different areas where you could be held criminally liable, either the 33 Act, the 34 Act, or possibly the what they call the federal mail fraud statute, as well as the federal false statements statute. You actually have to know that what you're saying is false for it to be considered a criminal act. So not too many criminal acts involving or criminal actions involving CPAs, but if you notice, the book mentions 4 of them. So please take heed. So they talk about the profession's response to legal liability. Number 1, get malpractice insurance. But having done that, seek protection from non-meritorious litigation. Have an ironclad, solid contract. Document everything you do, and then vigorously defend the case. That's how you take care of that matter. And then a couple of things they mention is improving auditing to better meet users' needs, educating users about the limits of auditing. Not sure that really helps, because when they have a loss, they're going to come for the CPA firm. Here they talk about, again, some things you can do. You know, certainly if members are sanctioned for improper conduct and performance, it's a way to drum out the bad seeds, hopefully, or at least sanction them temporarily so that they don't do it again. Tort reform might be, you know, I think there's some of that going on that is limited liability of CPAs. Other things they talk about, the way you can protect yourself, deal with honest clients, know your client's business, hire personnel who are qualified, maintain independence, maintain a skeptical attitude, and follow professional standards. Perform quality audits. Document. You always have to go into this with the mindset of CYA. What happens, have I protected myself in the case of a lawsuit? The way you do that is do quality work, document the heck out of it, and all these other things. Carry adequate insurance. Seek legal counsel. Seek legal counsel who know the auditing profession too. Choose a form of organization with limited liability. That way you can protect yourself from other individuals who may be negligent within the same firm. The end.